Welcome back everybody to our Law Studies series. In this lesson we are going to be talking about criminal intent. And this forms part of our series on criminal law for revision and studies purposes for level 3 members. This is the last of the sort of free content that I'm going to do, and then the rest of the lessons will be behind the membership paywall. And essentially in this lesson, what we're going to do is talk about mens rea and talk about criminal intent specifically. We'll explore a number of cases. We'll talk about what intent is, what mens rea is specifically as well, and the sort of distinction that you can make between intent and recklessness. And then we will sort of illustrate this point by looking at, like I said, a couple of cases that highlights the importance of intent when it comes to the criminal law, and recklessness and negligence when it comes to the criminal law, before exploring some more ideas about mens rea in the next lesson. So coming up over here then, straight away, we have to just think about what mens rea actually is. And so in terms of taking an introduction, we noted from previous videos that fundamentally, criminal law is divided into a number of aspects. It's important that when we want to try and find criminal liability, we want to try and show that criminal liability has taken place, that somebody is liable for the acts that have been committed that are a violation of the criminal law. There are generally a few different aspects that need to be shown. The first of these is this idea known as the actus reus, the Latin phrase actus reus, which refers to the act itself. It refers to the thing that is done, and we looked at that in the previous lesson. The thing that was done relates to the crime. So, for example, if it is murder, then what you have to do is you have to kill an individual. An individual has to die, and that has to be because of either an intent to kill or to cause grievous bodily harm. So the killing of the person being killed, is the actus reus. The mens rea, on the other hand, is what I just mentioned. It refers to the mental element, okay? The term mens rea of an offence is broadly defined as the guilty mind. It is defined as the part of the crime that refers to the mental element of it. So, mens rea in and of itself, okay, is not just an intention. Okay, intention is one part of mens rea, because mens rea could also be satisfied with recklessness, through recklessness or through negligence. So you have to make it very clear that when we think about mens rea, intent is very heavily spoken about in relation to mens rea, but it is not the only method by which liability can arise, or it is the only method by which we can show a mens rea. Therefore, we can't just suggest that mens rea and criminal intent are synonymous or that they are interchangeable, because you can have things where mens rea is satisfied, like I said, through recklessness. But fundamentally, when we think about intent, when we think about criminal intent, the intentionality element of mens rea refers more to the intention to bring about some event or some cause. So one of the things that I mentioned earlier on in this video is this idea of murder. Now, we know that murder requires the death of an individual. It requires a homicide. It requires somebody to be killed. But the mens rea for murder need not be an intention to kill. You could have intended to cause grievous bodily harm, and in doing so went a bit too far and ended up killing an individual. You would still be charged with murder, and you'd still be tried for murder, and you'd probably be found guilty of murder as well. So it is not necessarily an intention to bring about that very, very, very specific event to take place. It is often an intention to bring about some event or some cause, and that cause can lead to criminal liability in that sense. In terms of other elements of mens rea, we can also think about recklessness. So a mens rea of an offence could also, depending again on the defence, to a level of recklessness. This will depend on the offence that we are talking about, and I'll get to that in a little bit more detail in a second. But one of the things that is often mentioned is this idea of proof. How is it that we are able to prove an intention? Because it's very easy to prove the actus reus of an offence. That's pretty simple, because for the most part, you can see the acts that take place in the physical world, and then therefore we can piece those acts together, and we can come to a conclusion about who may have committed those acts. But mens rea refers to a guilty mind. It refers to the mental element of an offence. Now that's a little bit more difficult, because that requires us to have something of an insight into someone's mind. Surely, if we want to know with 100% accuracy whether or not somebody has committed an offence or has committed an offence with the prerequisite intent, we have to be mind readers. Well, technically, if you want to know someone's intent beyond with a sort of 100% accuracy, then you would technically probably would have to be a mind reader. But that's not the standard that we set for proving intent in the criminal law. When we think about mens rea, one of the questions that we have to think about then is how is it proved? How is it that we can show mens rea? Well, ultimately, the job of the mens rea, the job of the mental element, and therefore the job of the prosecution and the CPS in showing a mens rea, involves attempting to make claims about the internal thought processes of an individual. But obviously there's not necessarily direct evidence of that. So the prosecution is therefore not burdened with the task of proving a specific mental state, but the jury may be able to infer the intent from the relevant evidence. And this is really where we look at circumstantial evidence, and we look at all these different kinds of things. So, for example, if we have a murder situation, a man is killed and is stabbed by another person, okay, and there is a letter that the person who did the stabbing put down that said, "I want to stab this person," or "This person, I caught this person cheating on my wife with." Then you can probably infer from the evidence, from indirect evidence, from circumstantial evidence, the idea of potentially there being an intent. Now, obviously, the more circumstantial evidence there is, that the higher the resolution of intent can be shown fundamentally. But that's just one example, and this is codified in law. This is codified, as I've got on the screen here, in the Criminal Justice Act of 1967. Section 8 speaks about a proof of criminal intent, and it says the following, quote, "A court or jury, in determining whether a person has committed an offence, shall not be bound in law to infer that he intended or foresaw a result of his actions by reasons only of its being a natural and probable consequence of those actions, but shall decide whether he did intend or foresee that result by reference to all of the evidence, drawing such inferences from the evidence as appear proper in the circumstances." So fundamentally, what this piece of legislation, what this provision is telling us, is that if in determining whether or not a person has committed an offence, and in determining proof of criminal intent, we don't have to set the standard so high that we have to essentially prove that with 100% accuracy exactly what this person was thinking at the time that he had committed the act. Instead, we should try and infer intent or foresight by reference to all of the evidence. Get all of the evidence, look at all the circumstantial evidence, and make reasonable inferences about how this event has taken place. So this is really where we start thinking about intentionality in a little bit more detail. So I'm going to explore intentionality, then I'm going to just talk about a couple of cases that illustrates the point of intentionality. So we know that really intention is the sort of highest level of mens rea, and it involves the deliberate decision to bring about a particular result. We can delineate in English law intention into two categories. You have, on the one hand, something known as direct intention. This is where the defendant's aim or purpose is to bring about a particular result. So, for example, if we go back to murder, the defendant directly intends to kill or to cause grievous bodily harm. That's the mens rea for murder, to the victim. And if you then accompany that with an actus reus, the actual person dies and is killed as a result, then we have a direct intention and we have a murder charge that we could probably levy against that defendant. The second kind of intention is something known as oblique intention. This is where the defendant foresees that a particular consequence is virtually certain as a result of their actions, even if this is not their primary purpose. So, for example, if somebody sets a bomb intending to scare people, but knows that it will almost certainly kill somebody, then they may have also found to be having the oblique intention to kill and therefore be charged with murder. So, this idea of oblique intention essentially opens the door a little bit to the kinds of intents that can be inferred that can still give rise to criminal liability. Because if we could only use direct intention, then it must only ever have been the case that an individual who, let's say, kills somebody else had done so with the intention to bring about that result, i.e. to kill or to cause grievous bodily harm. However, with the idea of oblique intention, that opens the door to situations in which maybe the defendant didn't directly intend that consequence, but they should have known, and they would have reasonably known, that that consequence was virtually certain from their actions. So in the case of the bomb intending to scare people, you blow up a bomb that intends to scare people, you could prove in court all day long that your intention was only to scare people. That was your primary intention. But if it was the case that the consequence that you are being charged for was virtually certain as a result of your actions, for example, killing an individual, if you set off a bomb in like a high street, then you will have been found to have the oblique intention to kill. So we often describe intention in the criminal law as quite colloquially as a major component of the mens rea. But generally speaking, a jury will be directed to take intention as its ordinary meaning. There is not some fancy definition of intention that really is divorced from the English dictionary that the jury is directed to examine. It is just a general, or we take the word intent as its ordinary meaning in the English language. So let's look at some cases. Let's look at some cases that illustrate these points. The first case here is the case of Crown and Moloney from 1985. And what I'm going to do is I'm going to read the facts of the case, and then I'm going to talk about some of the questions that are raised as part of this case, and then I'll talk about how the courts deal with this case and how the courts ruled in this particular example. So beginning first then, the case of Crown versus Moloney was a case that involved a stepfather and a stepson. They had a very close relationship and they had decided to enter into a shooting contest. The shooting contest was essentially a contest in which they would see who could draw their guns quicker, sort of in the case of like a western or a cowboy, the good, the bad, and the ugly kind of situation. Now, unfortunately, in this situation, they had also been drinking, so there was a bit of intoxication that was sort of mixed into the process, which probably meant that their ability to draw the guns and their ability to do so in a safe manner was hindered in a somewhat of a way. The result of which was that the stepfather was shot and killed. Now, the question here for us in this particular case, for us in this lesson, was the question of whether or not intention on the part of the defendant to kill his father-in-law was present. Was there an intention on the part of the defendant to kill his father-in-law? Well, fundamentally, the conviction was upheld, at least at the lower courts, but was then reduced to manslaughter in the House of Lords. And really, the facts of this case aren't necessarily as important as the House of Lords, in their judgment, spending a little bit of time clarifying the issue of intent within the criminal law. They say that in order for a person to be convicted of murder, they must have an intent to kill or to cause GBH, or to cause grievous bodily harm. The Lords made the argument that the foresight of the consequences in and of themselves, without a direct intention, is insufficient for a conviction of murder. It was made clear that the key consideration should be the defendant's purpose and whether there was an intention to bring about a specific result which would give rise to criminal liability. If we move on then and look at a case from 1975, the case of Hyam versus the Director of Public Prosecution, we see again a number of issues and a number of facts that we can illustrate. The facts of this case were as follows. The defendant was in a relationship with a man, and when this relationship had ended, the defendant had become increasingly jealous of her ex's new partner and fiancé. So this bloke, basically, they broke up, and this bloke went and found somebody else and proposed to this individual and was in the process of getting married. And all while this was happening, the defendant was increasingly jealous of this new partner. And the result of this was that she would pour petrol into the new partner's letterbox and then set it alight, okay, in a sort of act of vandalism, maybe an act of threat. It's quite hard as somebody who isn't a stalker to get into the minds of somebody who is. So fundamentally, that is what happens. The resulting fire would end up killing the new partner's 2 young children. And the result, of course, is that the defendant was tried for murder. Again, when it comes to legal issues, the question here was whether or not the defendant could be convicted of murder, since they did not have an intention, they did not have the intent to kill the 2 children when performing the act. And so, fundamentally, the defense said, well, how can you try and convict this woman of murder if this was not an intention, if there wasn't an intention to kill the 2 children? Well, it was held by the courts that the jury at least held that there was a conviction of murder, and the House of Lords on appeal actually upheld this conviction. They did so on the basis of a number of reasons. Generally speaking, these all hinged on whether or not the defendant knew it was probable that the children were in the house at the time of the act. And so, like we spoke about earlier when we looked at the idea of oblique intention, even if, okay, the intention to kill or cause grievous bodily harm wasn't the primary goal. It wasn't the primary intention. It was just it would have been at least the case that because she would have known, given a certain sense of probability that the children were in the house at the time of the act and that the act would have caused a lot of damage and injury and possibly death, it had to be the case that this intention to kill or cause grievous bodily harm was potentially an intention. It was an intention rather than it being necessarily the intention, if that makes sense. The intention might have been just to be jealous, to make her ex's new partner scared or whatever. But given the likelihood that she would have known, the probable likelihood that the children were in the house at the time of the act, and that the act was going to likely cause a lot of damage, injury, or even death, it was probably the case that she had an intention that could be inferred from there. Finally then, let's just talk about the case down here of Crown versus Woollin from 1999. This case provides, as I just provide a little bit of context for this case provides and sort of clarifies this test for oblique intention. So you might be a bit confused thinking, well, how does oblique intention really work? Well, oblique intention essentially, this case essentially states that if a consequence is a virtually certain result of the defendant's actions, and the defendant appreciates that fact, they appreciate the fact that this was a virtually certain consequence, then a jury may be able to find that the defendant intended that consequence. And this speaks to the heart of intention. Because from a sort of colloquial perspective, we can understand what intention means. We can understand that intention refers to this idea of wanting to bring about a thing, okay? If I pick up this mug of coffee in my hand and I go to sip it, I'm intending to drink coffee. I'm intending for this coffee to go into my mouth, okay? And to wake me up a little bit. That's the intention. But we can also appreciate, colloquially, as people that sort of live in a society and have grown up in the society, that intention need not be that blatant. It need not be that obvious, and it need not be that straightforward. It could be the case that you are doing something, and you are doing something at least with the open intention of achieving some result, but you know in the back of your mind that this other result is virtually certain. Okay, and you appreciate that in the back of your mind that if I do this thing, okay, I know it would be virtually certain that is what's going to happen. An example that I've just sort of plucked out of thin air right now is when you were a kid. And let's say you were a kid that had to wash the pots after dinner, okay? Did you ever deliberately wash the pots a little bit rubbish, okay? The intention in that case, did you ever just deliberately, do a bad job at washing pots? The intention in that case, the intention in that act directly is to wash the pots. That is your intention. But you know in the back of your mind that if you perform this action in the way that you're doing, there is a sort of secondary intent. There's a secondary cause that is being brought about. That is your parents not asking you to wash the pots again because you did such a bad job. That's just one that I've plucked out of thin air. But it illustrates the point. It illustrates this idea that when you think about intention, that it need not be so obviously point A to point B, that there are other things that go on in the background that you definitely know about, that maybe you don't mention, but that you know are going to be caused as a result of that. And so when we talk about oblique intention, essentially the point that we are making here is that if a consequence is a virtually certain result of the defendant's actions, and the defendant knows that is the case, and they appreciate that, and it can be shown that they can appreciate that, then a jury may find the defendant has intended that consequence. So let's look at the actual facts of this case and how this was essentially spoken about. So the facts of this case involves a 3-month-old child and the defendant. In the fit of rage, the defendant would kill his 3-month-old son by throwing him into a hard surface. Now, at the trial level, the judge directed the jury to convict if they were of the mind that the defendant realized the, quote, substantial risk in the action committed by the defendant. This was seen to be an incorrect direction to the jury. This was an incorrect jury direction on appeal, because on appeal the conviction was reduced to that of manslaughter. And this idea of substantial risk, okay, was essentially scrapped. So this sort of substantial risk standard was incorrect. The reason for this is because it would confuse intention with recklessness, and what the distinction between intention and recklessness does is delineate between murder and manslaughter. So if you are basically imposing this substantial risk standard for oblique intention, then you are then confusing intent and recklessness, which could confuse murder and manslaughter and cause a bunch of problems in the criminal law in the future. So instead, the jury would be asked 3 questions relating to the issue at hand for jury direction in the cases of like this when it comes to oblique intentionality. The first question is the result for which criminal liability exists one which was virtually certain consequence of the actions of the defendant? That's the first question. The second question is, did the defendant know that this action would be a virtually certain consequence? And then finally, given the evidence, would the jury be satisfied with the finding of that intent? Okay, so oblique intent is essentially defined by these 3 questions, which we know about already, really, but I've just split it up, or the courts have just split it up into these 3 questions. Is the result for which criminal liability exists one which was a virtually certain consequence of the actions of the defendant? So in this case, we're talking about in a fit of rage, maybe when you have a child and the child doesn't stop crying and it causes quite a lot of stress. It can cause people to shake babies. It can cause people to be a lot rougher than expected, which will then obviously result in injury and potentially death to the child. In these cases, it is probably not the case that shaking a baby or throwing a baby in a certain way was done with the intent to kill the child. Okay, it was probably done in a different way, out of frustration, out of stress, out of sleep deprivation, etc., etc., etc. This is not a defense of these actions, by the way, but this is just finding a different kind of intent. But with that being said, that might not be the direct intent, but it would still nevertheless satisfy the oblique intent, given the fact that in this circumstance, would throwing a baby at a wall or a hard surface, or shaking a baby in such a way, is the result for which criminal liability exists, one which is a virtually certain consequence of the actions of the defendant? Yes. Did the defendant know that action was a virtually certain consequence? The answer would be yes as well, because a defendant, coming at the defendant from the perspective of having a basic knowledge of a human, would come to the conclusion that treating a human or using that much force against a human, especially one that is so young and so fragile, would cause the consequence that ends up happening. And this is really where we think about oblique intentionality. So really, this is this idea of criminal intent. If you want more lessons on this kind of subject, on the criminal law and all the other core modules, in this sort of mind map kind of way, so you can just sort of follow it along, and you can make notes as you go, and you can sort of visualize the topic in a more holistic way rather than just reading a textbook, then do go and get yourself a level 3 membership. I'm going to be doing these lessons for all of the core modules, any of the additional modules that I'm doing, all of the international law module as well. I'll be doing these for those too. And in these lessons as well, I'm going to include some additional content and additional material. So make sure you get yourself one of those, so you can follow along with these lessons as well. And you also get access with a level 3 membership to a whole bunch of case summaries videos, a whole bunch of additional videos on the criminal law and other core modules. You also get access to about 4 or 5, I think 6 in fact, different modules on international law. So law of the sea, for example. You get some international criminal law, some laws of war videos as well, all of which are on the level 3 membership page already, in addition to getting access to every lesson that will be free early as well. So you get quite a lot for these for these memberships. So I hope you enjoy this lesson, and I will hopefully see you back in the next one.